What instruction you okay?
Pertaining to their interest, your lordship, or whether
That is the decision of the court.
matter may fix for hearing, your lordship.
Or Deborah Garden. Peter. Yes, you go.
I'm for responded it. I'm accounting general. I'm on behalf of accounting general. I have specific instruction that we have absolutely no role to play in this matter.
Pardon?
I have specific instruction that we have absolutely no role to play in this matter. Therefore, our name may be excluded. Your lordship, even though there is no affidavit or I file, my lord, I just, if your lordship permits me, I'd like to place the instruction. If your lordship pleases, your lordship may kindly strike out our name.
So we'll finalize it.
That's all right.
Then their name may be not talk of my lord till that final dispute.
Because we have no role to play in this.
Tini second copy.
Therefore, there is a specific instruction that second para, my lord.
And also her that
D. Bhattacharya.
the protested blood appearing on behalf of the both of person. You are appearing on behalf of
Respondent 8, accountant general.
no, this letter
But that is old letter, my lord. This was addressed to previous council.
respondent number 8.
Lord,
And Madam, what for respondent number
17.
7? You 4, 5, and your name please. SK.
Independent.
Right. So for us, that purpose will are by referring to members of the meeting. So it is accordingly provided that there is a list of better court case.
Video. Remind what we take recording.
16th of September. On
Fifth of-
that day, an interview will be made by the hearing.
15 this 16.
16. Oblige.
my lord is keeping that letter on record.
This letter,
Yes, sir.
2018.
You follow, my lord?
This letter is of 2018.
I understand. Ma'am. Then you have to. That may not.
Part in the first letter, then
Then your lordship.
It is a my lord part of the record letter.
letter.
And this letter was
That letter is
I understand, my lord. It's nearly 10 years old. I understand that.
you can take it back.
All right. Oblige.
Deeply. Tini second copy to Diana. Please second copy.
On the case for the hearing. I think the event of the are you appearing here?
Yes, your lordship.
That's the number.
I am for I'm appearing for respondent 1, 2, and 3.
Then Madam
1, 4.
1 and
1,
only
or 4. 1, 2, 3, and 5. Inspector. Deeply obliged.
For the private respondent matter, the matter is apportionment of pension between mother-in-law and daughter-in-law. The son died. On the last occasion, I was
you are for respondent number.
private respondent,
That is the
Yes.
number.
number 6, madam.
Other place for the home officer.
DK Nath.
You cannot turn it. Then you go.
I am for
This is the matter after 1 week. So at the hearing, represent appears for the part.
Look, the department I am paying with.
Of part that both of five then prior that they all both were the of the order date and the order dated for it, it comes for non-prosecution. Uh, Implemented is a matter of conflict. The event of non-prosecution.
And appear on item number 9 law. Eight and 9 is. But the vote is not same lot, it's not identical with the item number 8. Item number 9, I have challenged my cancellation order. In the item number 8, I have checked. They are claiming the pensionary benefit.
One by one,
Lot.
so, non-appearance for the with the matter after one in the event.
Your Lord, I am clearing item number 8, respondent number 4 and 5.
Or that
DC not.
is not part of it. Then the respondent authorities here you are
No.
elementary education.
Okay.
9. My case may be segregated, man. Item number 9 may be segregated. This is not the identical.
Can we refer the matter to the
Lordship.
can we refer the matter to the magistrate?
No, so I have to challenge my cancellation order for which of service.
Or appearing for respondent
Yes, ma'am. I am the elementary department, my lord.
for
2, 3,
three.
2,
Oh.
3, 8, and 9, my lord.
No, in item number 9.
Yes, my lord.
In item number 9, there is only 4 respondents.
Fine. Item number 9, yes, ma'am. Oh, okay. All department, my lord. Oh, sorry, all the respondents. And
The third item of the court of purpose by reference and that it is not within the but matter may be segregated.
my lord, kindly matter maybe may not send my lord to the mediation. We have to verify, my lord.
We have to update.
Baba,
Accordingly, provided that this matter happened. For admission hearing,
Okay.
fixing the matter
after two,
after
weeks.
Good.
Repeat.
It's listed for mediation, man. We are ready for mediation if they want.
Lordship, as per my instruction, Your Lordship, final withdrawal of GPF money in respect of the petitioner, Inspector of School, that is North Lakhimpur, has been sanctioned wide letter so and so dated 17/1/2025, and as informed by Dr. Chutia, he has received the GPF money wide letter number so and so dated 24 March 2025. And thereafter, Your Lordship, pertaining to GIS, has been sanctioned white letter dated so and so on dated 4/2/2024, and provisional pension has been sanctioned white so and so. Further, regarding leave admissibility report or the AG white letter number so and so dated 9/5/2025 requested to furnish the information regarding leave contribution and pension contribution for the period of 11/11/2022 28/6/2021 from SEC in respect of, that is SEBA, in respect of Dr. Ramesh Chandras Chutia, who is the present
Perhaps
Oh.
I'll have been
present
another case,
petitioner.
reading another case. I
This
think
is
10.
11.
Huh?
This is 11.
10 has been.
Oh, Liaquat Ali, oh sorry, Your Lordship. Your Lordship, pertaining to the Liaquat Ali Mazumdar, Your Lordship, I may file our affidavit, Your Lordship. Some instruction has already shot for Your Lordship, which is not received. Other, Your Lordship, affidavit, we needed to file our affidavit.
Now the effort to the matter
No, Your Lordship. Oh, are you confused? হয়ে গেলো না?
Already short that way, I'll leave it because
according
I have been deprived from legitimate pension.
to on fixed
All right.
Deeply obliged. Delay. Yes.
I pay for the office of the AG in this matter. The pension papers have been returned back to the department due to some mismatch found in the documents regarding the last paid on. And so far as leave encashment benefit is concerned, the government has forwarded to us the sanction letter on 20th of this month. So it's under process. Within a week, will allow the disbursement of the leave encashment benefit amount. So far as the pension papers are concerned, we have returned it later. Letter from them. Later.
where is the letter?
The leave encashment document I have mailed it to the official mail. But so far as the return of pension papers are concerned, it's just the written instruction that I have received just now, 5 minutes ago. Papers have been returned back. It says that as per Form 7, last pay found was 87,980, but as per PIS, it is 90,620. Mismatch in last pay. We return pension case due to mismatch of his last pay. This is the instruction.
Forward for your comment. This part we are not aware, Your Lordship. So we may take instruction regarding this, Your Lordship.
Yeah.
My senior
You
is
have
out
to
of
keep the
station.
leave engagement.
Your team, my senior is out of station currently. Kindly attend the matter.
Or name,
I'm not in this case, my lord.
your name,
Please, sir.
your name,
Please, I say.
Multiple court.
See the basic
AG, my lord.
number
5.
number 5.
I'm a
1 and 3. 1 and 3. Your name please.
I'm appearing for 3. 1 and 3. School education more hai, huh? Your Lordship, I am appearing for respondent 1 and 3, secondary education. And he should be 4.
Teacher
3 more hai right thikile. A receive. Yeah, na that. Sorry. Disappointed. Please.
appearing for
Team पे है right thikile pai.
One is
Let it be up to 2 weeks, my lord, because it has been
Sorry.
returned back, so it has to come again, the pension paper.
easy. The petitioner has already been paid.
No, the government has sanctioned the leave encashment. Now we'll issue the payment order. Within a week, it will be.
The
Team to more hai right.
We'll authorize the payment.
easy with
Mukman asile 1 and 3 no.
Authorize the payment.
authorize the payment. Authorize the payment. With the payment. Take
It will-
1 week time.
Thank
And
you.
that the pension paper. Mismatch in the pension paper.
Mismatch in the last pay drawn. Last
Last
pay drawn.
pay drawn.
Amount
In
to
the
pay.
57 and the PIS statement.
And the
PIS statement.
statement.
You get to
The
forward.
pension paper, the cooperative return to the department.
Department. Okay.
Deeply organized.
The admitted amount per loss may take up the matter on 5th of October, my lord. I'm not ready for the mediation.
5th of
5th of October, my
I take the care. And the third
5.
5. Then six. Yeah. The price for this matter on 5th of October.
My
Yeah.
Obliged.
5th of October is a Sunday.
5th of October is the, my lord.
October or September?
September, I'm sorry, September, my lord.
Okay.
September.
Lordship, kindly let this matter be taken up after some time. My senior counsel is in another.
In this case, my lord, the record relating to the communication dated 28/6/1993 was called for. My lord, whether that record is ready or not, my lord. 28/6/1993. Yeah. Okay.
record already received, Lordship.
The
That already-
last occasion they stated that record has been received.
Records received, your lordship.
The record of 28/6/1993.
To Nohinder Guru. Your Lordship, in this matter, Anjay Khataniar will be appearing, so kindly pass over the matter for time being.
After some time.
Great Lord. My Lord, the petitioner before Lordship was an employee in the Tazpur University. And on on 6th 2006, my Lord, he opted for resigning his post there and to go to another institute. And after resigning, my Lord, he claimed that since he has retired under the pension rules, he is entitled to get pension. He should be allotted pension to him. But the university took a stand that since I have gone away from here and resigned service, so the next institute will grant me pension. That I challenged before the Honorable Court, my Lord. And the Honorable Court, by a detailed judgment, your Lordship will find at page 24, held that since I am an
This
permanent
matter
employee,
is, no, this matter is listed today for admission hearing. So you are ready to argue the matter?
my Lord, but it's small matter, my Lord.
Sir.
Once
Yes, are you ready?
Your Lordship, Mr. SCKL is on legs right now, Your Lordship. Matter may be adjourned for the day.
Why?
no adjournment is difficult, my Lord, because since 2006 he has not
Yes,
been denied.
We
He has
have
been
done the
denied.
adjournment subject to payment of cost. Are you ready to pay
Your
the?
Lordship, then it may be passed over for the time being, Your Lordship. Mr. SCKL will appear. He's on legs.
Always he is on like.
Maybe pass over for time being, Your Lordship.
And the Lordship will see, Honorable Court held that since he is a employee, permanent employee of the Tazpur University, he is entitled to get the pension from there. And in spite of that, my Lord, they went against that order to the division bench. Division bench also maintained that position, my Lord. And after that, my Lord, when it is that is confirmed that he is entitled to pension, instead of paying pension, my Lord, they have given him a lump sum amount, my Lord, telling that he is not entitled to pension, without any reason, without any that your Lordship will find at page 43A. By this order, my Lord, capitalized value of pension.
Let her continue.
My Lord, my Lord.
Or you will be able to argue the matter. Argue, okay, no problem.
Your Lordship, Mr. SCKL will appear in this matter, Your Lord.
Then ask him to
Yes,
come
sir.
immediately.
Yes, sir.
Okay. Okay. Sophia, you please.
My Lord, I'll be here.
None adjustment of it. How about? Matter after.
Deeply obliged.
May it please the Lord. And I pray before Lordship, your Lordship order, my Lord, I'm similar, same, everything is same, my Lord, same appointment, same, my Lord, regularization. My Lord, your Lordship order, my Lord, page 89, my Lord. I'm praying for the similar prayer, my Lord, similar.
Before my senior argument, my Lord, I pray some accommodation, my Lord. Yesterday morning, I have received the parawise comment, my Lord. So Lordship may allow me 1 week time to file our affidavit.
Today is the last chance your
Last
order,
chance, as per last order, my Lord,
2025. And
but,
earlier order also, these are similar, my Lord, they can verify, they says, Mr. S. Sutia says that, my Lord, by order dated 26.
After notice, my Lord, the Honorable Court
So whether the petition
gave
is
us last
covered.
chance, my Lord.
Already
If your
heard.
Lordship see the order, my Lord, after notice, my Lord, Honorable Justice Nelson Silos order,
No,
Honorable
this is
Justice Kaushik Goswami give us last chance, my lord. So I pray for 1 week or 2 weeks time, my lord. Yesterday morning I received. If,
So I may be allowed to hire.
if he has urgency, my lord, so
Because of that, he's a retired person, she is a my lord. And her case is just after verification, that order, your lordship, operative portion, my lord, please make it page 100, my lord. Page 100, para 12, your lordship order. Under the given facts and circumstances and also taking note of submission of learned council board parties, this court is inclined to dispose of this petition directly respondent to verify the service particulars of the petition, and if it is found that case of the present petition covered appropriate judgment. Purnima Hora already mentioned, your lordship.
Sir,
my lord.
sir, the present petitioner is with the of the part 65 of the
That I have to check up, my lord. So I pray 1 week, some little accommodation, my
law. If the matter is
lord. My lord,
the petitioners are similarly then the relief can be granted to them.
দেখো না যেখানে করবো ঠিক তোমার করে পেলে পাস করবা সিমিলার ভেরিফাই
Okay, let it be on like
Tuesday, my lord.
next time
Tuesday.
My lord, my lord, my
and for the current and sir, he the current
I, for I can verify.
Talukdar topic that yesterday he did the paragraph comment with file and affidavit and that was granted on the time that Tuesday.
Obligement. Deeply okay.
endeavor shall be made, dispose of the same day, man. Endeavor shall be made, dispose of this petition on next week.
Observe
Yes.
favor
Much.
I think I don't know. 13, 18.
Lordship, here the petitioner, he was working as a deputy registrar in
let him argue first.
Lordship. Was a permanent employee in Itasburg University that are stated Milan. And since I was not given pension by the university, I came before your lordship, Honorable Court Milan, and as I stated, the Honorable Court by an order in WPC 7416 of 22, by order dated 9/1/24, finally stated at page 36, your lordship will find the page 36. Accordingly, this petition, paragraph 23 minutes.
Yes.
Accordingly, this petition is disposed of directing the respondent, Itasburg University, to release the pro-rata pension payable to the petitioner. In view of the finding of the court, as discussed about the impugned order that the demand is set aside, Itasburg University will calculate pensionary benefits payable to the petitioner and releasing the amount and accurate it as possible within a limited period of within an outgoing limit of 60 days from the date of receipt of the certified copy of the order. Against that, they went to the division bench. And next, Milan, division bench has order 38. Last paragraph, page 38. It is clarified that the order dated 36/24 was passed by this court while hearing the learned counsel appearing for the party at length and finding that no case for interference is made out against the impugned order dated demand passed by the learned single judge dated demand, which is observation directed. In spite of this order, Milord, instead of paying me pension, they paid, as I have stated, Milord, by this order dated July 21, 23. No, I'm sorry. By
by 3724 order at page 39. Along with retirement gratuity and cash equivalent of the unutilized leave, they paid me capitalized value of pension. That is 24 lakhs 56,484. And by that, the earlier order by which pension was calculated, that was cancelled. I will take your lordship for this capitalized value. At page 43, this was the pension order they have calculated in my favor. This is for number one is Asuk Singh. There in column about 6 or 7, you will also find capitalized value of pension. That is 24,56,485. That's exactly what it is given. And that amount is for commutation of pension. Commutation of pension. If one wants to commute the pension for a period of 12 years, then it is calculated that way and that is given to him. I have never asked for it. And my prayer for pension. And pension they have also calculated, your lordship will see. Pension, about 6 lines from the bottom, 50% of the pay. That is there, my lord, in the pension rules 40, I think. Pension they have fixed, my lord, 23,050. Instead of paying this monthly, they have this capitalized value. Commutation amount they have given. It is by this, my lord, they have made mockery of the Honorable Court justice delivery system. I will humbly submit this officer is liable for contempt, my lord, of the Honorable Court. Capitalized value, my lord, which is computation amount. So I pray for passing of this order, my lord, and for directing the respondents to release the pension, monthly pension from 2006, my lord, till the date. In almost 18 years, my lord, I am without pension. Rule Rule 44, my lord, in the pension compilation.
Page number.
My page number is, my lord, 114. Chapter 7. 44 rule. Government servant who retires under Rule 33, Rule 34, 35, Rule Iman, after completing qualifying service of not less than 10 years shall become eligible for the grant of pension calculated at 50% of the emolument or average emolument, whichever is more beneficial to him, subject to the minimum of Iman. Accordingly, this calculation was made here. You will be surprised to see, your lordship. His salary in column 10, they stated pension, 50% of pay drawn, total pay was 46,100 and 50% is 23,050. And even after this note, even after the direction of the Honorable Court, they are not complying with the order, in fact, violation, making this Honorable Court a laughing stock, my lord, before the public. I will pray, my lord, that contempt proceedings should also be drawn against this officer, my lord, for violating the court's order. Because question whether I am getting pension or not at this stage, it cannot be re-agitated. This court and your division bench also has fixed it, my lord, made it. In this regard, my lord, I will also refer to it is an establishment and an administrative and administration of Swami's compilation, my lord, book is not right. I am told not available. How these central government people are absorbed in the employment of the central institutions like the university, my lord, owned by the central government. There is this certain, my lord, after he becoming permanent, my lord, he becomes a permanent employee and will get all the benefits from the date he joined the central government service as a permanent employee, my lord, of the institute. And by that, my lord, he is entitled to pension, not this computation of pension, capital value of the pension.
Okay.
And
What is the citation of that?
I book I am giving, my lord. I am passing in. Chapter 52, it is marked already. Only some elaborate statements are here, my lord, from the pension rules. And on the last occasion, my lord, while the matter was taken up, my lord, he was telling that pro rata pension is not pension proper. But pro rata, my lord, this book in the index, they have explained pro rata means the benefits on permanent transfer. Since in this case also I am permanently transferred to the institute, my lord, I will get the same benefits at the same rate, my lord.
Yes.
These are my submissions,
Right.
my lord. In view of this, I will humbly submit, my lord, while crossing the order, my lord, your lordship will also direct that contempt proceedings be also be drawn against the officer, my lord.
May I please? Only two facts not in place before your lordship. The petitioner was not permanent employee of the Tezpur University. He was appointed as the assistant registrar. I'll place lordship may come to directly to the page 38. Order of the division bench. Thereby the university has challenged the order before the division bench. Page 38. Only last paragraph was read, placed before your lordship. Page 38. May I read, Lord? In view of the said affidavit dated 11/6/2024, filed by the respondent, number one, we dispose of the writ appeal with a direction to the Tezpur University to pay the pro rata pension amounting to the respondent number one, as directed by the learned single judge by the impugn order dated impugn order, while making it is clear that after receiving the said pro rata pension amount, the respondent number one has no right to raise any claim against the Tezpur University for benefit, including pensionary benefit. Now, lordship, come to my affidavit. How the lordship facts has been resorted, not placed before the learned court. Lordship affidavit filed by the registrar, Professor Kailash Chandra Viswal.
Lordship got to.
affidavit is dated 8th of May 2025.
Lordship. Lordship, paragraph 3.
Yes.
That before giving Paravai's reply to the averments made by the writ petitioner in the writ petition, the respondent begged to state that earlier the writ petitioner was working as assistant registrar in the Indian School of Mines at Dhanbad. He had applied for the post of deputy registrar at Tezpur University. On being selected, he joined the Tezpur University on 2000. After being released by the Indian School of Mines, Dhanbad. Thereafter, the service of the writ petitioner was confirmed in the post of deputy registrar with effect from 22/5/2001. Thereafter, the writ petitioner brought to the registrar Tezpur University for transfer of post service benefit from the previous employer. The Indian Institute of Mines remitted the pro rata pension benefit of rupees 5,79,752 to the Tezpur University. 1. Paragraph A. The writ petitioner thereafter applied to the post of registrar at Neris, Nerjuli, Itanagar through proper channel, and on being selected, the writ petitioner was released from Tezpur University on 15/2/2006 with lien of 1 year, enabling him to join the post of registrar at Neris, Nerjuli, Itanagar by office order dated 15/2/2006. Subsequently, the writ petitioner applied for the extension of the lien for 1 year, that is with effect from 16/2/2007 by his letter dated 7/12/2006, and he was granted lien of 3 months with effect from 16/2/2007 by order dated 19/4/2007. However, the writ petitioner submitted his technical resignation from the substantive post of deputy registrar at Tezpur University with effect from 14/5/2007, expressing his desire to continue as registrar Neris by his letter dated 24/2007. After considering the technical resignation submitted by the writ petitioner, he was finally released from the service of Tezpur University with effect from 14/5/2007 by office order dated 15/5/2008. B. The respondent begged to state that the registrar Neris, by his letter dated 12/9/2019, addressed to the registrar Tezpur University, informed that the service of the writ petitioner Sri Ashok Singh was terminated during probation period due to involvement in criminal activities in the campus, and a criminal case was registered against him in by him. My lord, without interrupting, Lord, your lordship is not hearing a review. This is not a review. Yes. It is an order on the basis of the order passed by the single judge. When the order has always been said that Tezpur University is liable to pay pension, how these things come in here?
This is the affidavit in opposition.
Yes,
filed by
this
the-
is an affidavit. That is open.
Yes,
No
they-
doubt.
You file their reply.
He cannot put in everything and without, yeah, Milon.
Lordship, no
Without
pension
malice.
is, 1% employee is entitled to pension when he is retired from that institution. He is not retired from that Tezpur University. Lord. All these facts have been suppressed from this honorable court. Lordship, thereafter I will place, please to see. The respondent begged to state the registrar Neris by his letter dated 12/9/2019 addressed to the Tezpur University informed that the service of the writ petitioner Sri Ashok Singh was terminated during probation period due to involvement in criminal activities in the campus, and criminal case was registered against him in which is pending, and as such the termination benefit cannot be settled for final outcome of the case. Then we have annexed all letter. Let's see paragraph 6, next please. Another lordship, the respondent begged to state that thereafter the writ petitioner, by concealing the materials information of his termination by erstwhile employee of employer Neris and pendency of the criminal case under section 226/307/34 IPC on the date of his making application selected and appointed was also concealed by him. He further got endorsed by the Vice Chancellor his application for appointment as registrar Banaras Hindu University, Varanasi, by giving false information. He got appointed as registrar in the Indira Gandhi National Tribal University, Amarkantak, Madhya Pradesh. Thereafter, on discovery of this information, the writ petitioner was dismissed from service of Indira Gandhi National Tribal University as per Statute 26(5) of the Indira Gandhi National Tribal University, with act form is suspension, that is 12/22/11/2022. Lordship may now come to annexure. Page 52.
But petitioner is making that university, the officer of university has committed contempt. Lordship, see the conduct of the petitioner. Lord. Page 52. Office order dated 15/5/2008. Sri Ashok Singh, Deputy Registrar, Tezpur University, who was granted extraordinary leave with effect with lien from 15/2/2006 to 14/5/2007 to serve the Northeast Regional Institute of Neris, Nirzuli, Itanagar, Arunachal Pradesh, as registrar is hereby released finally from the service of the Tezpur University on submission of technical resignation under the provision of FR so with effect from 14/5/2007. Now let's see next page 53. This is a technical revision of the petitioner. This is dated 24 July 2007. I was released initially for 1 year on extraordinary leave with effect from 15/2/2006 to join the post of Registrar Northeast Regional Institute of Science and Technology. Later on, further extension was given for 3 months. That is from so and so. Further extension could not be considered as I was asked to resume back at Tezpur University, while later dated so and so within 1 month. Director Renis has also given its consent, while later dated so and so. Considering the above point, I have decided to continue as Registrar Neris and to submit my technical resignation from the substantive post of Tezpur University at Tezpur University, and as such, it is requested that my technical resignation with effect from 14/5/2007 under FR 22 of CCS pension rules may be please be accepted. So from Lordship 14/5/2007 is not employee of the Tezpur University. Then Lordship next page 54.
Where is the letter for acceptance?
Lordship,
Where is the letter of acceptance?
Lordship, it was accepted. Lordship, page 52.
It is the acceptance order.
Yes, Lord. Then Lordship, please come page 54, Lord.
Yes.
It is written by the Registrar Tezpur University to the Registrar Tezpur University. Data dated 12th September 2019. Information regarding service record of Sri Ashok Singh, ex-Registrar Neris. In reference to the above referred letter, the following information is furnished herewith regarding settlement of issue of Sri Ashok Singh for payment of pensionary benefit by Tezpur University due to non-receipt of the approval from the Ministry of HRD has not implemented the CCS pension rule for his employment till date. The service of Sri Ashok Singh, ex-Registrar, was terminated during the probation period due to involvement in criminal activities in the campus. Further, the criminal case was registered against him is pending before the Honorable Court, and as such, the terminal benefit cannot be settled from this until final outcome. Now, Lordship, next page. It is a very interesting. It is a letter of Indira Gandhi Tribal University, Lordship, by the Vice Chancellor. Merit Lord. Whereas Sri Ashok Singh, Registrar under suspension, was issued a charge sheet by letter dated 15/5/2012, and whereas a departmental inquiry was instituted by the Executive Council against Sri Ashok Singh, and wherein he was granted full opportunity to defend himself, and whereas by the inquiry report dated 26/2013, the inquiry officer has reported charge number A, B, and C, and also charge D11, D12 as proved against Sri Ashok Singh, and whereas Sri Ashok Singh was issued a notice on 3/4/2023 2013 along with the inquiry report, and which he submitted a detailed reply dated 24/2013, and whereas the detailed reply of Sri Ashok Singh dated 24/2013, which was received in the office on 24/2013, has been considered by the Executive Council, and whereas the Executive Council, which is the appointing and disciplinary authority, after examining the entire record, departmental inquiry, the report of inquiry officer, and the detailed reply of Sri Ashok Singh is fully satisfied, and in view that Sri Ashok Singh secured appointment as registrar by concealing the material information of his terminating by the erstwhile employer Neris, the pendency of the criminal case under section 326 307 34 IPC on the date of making
application selection and appointment was concealed by him, that he further got endorsed from the Vice Chancellor his application for appointment at Registrar Banaras Hindu University by giving false information therein that he misconducted and sought insubordination in discharge of his duties as Registrar Sri Ashok Singh, thus secured appointment as Registrar by deceased and other misconstitute as an officer of INGUT, which is unbecoming a person holding such responsible post. And whereas the independent examination and after discussion on individual charge number A, B, and C and reply of Sri Ashok Singh on the same particulars, his confidential letter dated 1/10/2012, the EC is satisfied that Sri Ashok Singh secured appointment as registrar by concealing material information with regard to his termination by erstwhile employer Nerist and the pendency of the criminal case against him. Now, therefore, the Executive Council has taken a decision to dismiss Sri Ashok Singh, registrar under suspension from the service of the Indira Gandhi National Tribal University, as per Rule 26(5) of the IGNTU, with effect from the date of his suspension dated 22/11/2012. Hence, Sri Ashok Singh is hereby dismissed from post of registrar so and so. So, Lordship has seen in 2006 he resigned from he was not employee of the Tezpur University. All these materials have been surfaced by him. It was not disclosed by him during the first petition also. Lordship has seen the division bench order, and Lordship, his affidavit may kindly be seen, which I have annexed along with my affidavit. Lordship, page 59. This was the affidavit submitted by the petitioner before the division bench on being order passed by the court. Paragraph 3, page 59. That the deponent submit that the above calculation of pension and other required benefits are required to be paid to the deponent in view of the service he has rendered in Tezpur University. The deponent submits that he has no further claim in the matter of disposal of his pension and other retirement benefits. And accordingly, the order was passed. Lordship, page 38. The reference was made to that affidavit also. Page 38. Again, I will already place before Lordship. Page 38. In view of the said affidavit dated 11/6/24 that I have read placed before your Lordship. While by the respondent number 1, we dispose of the writ petition with a direction to the Tezpur University to pay the pro rata pension amount to the respondent number 1 as directed by the single judge at impugn order, while making it clear that after receiving such pro rata pension amount, the respondent number 1 has no right to raise any claim against the Tezpur University for any benefit, including the pensionary benefit. And thereafter, Lordship, as per direction of this Honorable Court, we paid the entire pro rata pension to the petitioner, not to the Nerist. As per rule, we have to transfer this amount to his immediate employer. But as per direction of this Honorable Court, we paid to him to directly. And all these materials were suppressed before this Honorable Court. So this petition is liable to be dismissed with exemplary cause for misleading this Honorable Court. He has given undertaking before the division bench, and Lordship knows that pension is employee is entitled to pension for the employer when he is retired from that university. But here Lordship has seen that he is after that Lordship he applied in two institution law. That is as well as in the
Where is the undertaking?
Lordship. I have given Lordship the affidavit filed by him. I have annexed with my affidavit law. It starts from page 57. Page
Not messy paragraph 2 also there. He read paragraph 3.
Lordship, entire affidavit I am placing to. Page 58.
Yes.
I Sri affidavit on behalf of respondent petition Ashok Singh. I Sri Ashok Singh, aged about 66 years. Do you have shown information as under that the deponent is filing this affidavit as directed by the Honorable High Court by order dated 3/6/24. That is also important to be looked into. Law. A specific direction was given to the petitioner that he should file an application that he is not entitled to any pensionary benefit from the Tezpur University. This was the order, Lordship. Lordship, may please call for the record and may please to peruse that order also. This is a Lordship, this is a high misleading the court law. And the submission is made that we have committed the contempt. If it is so, Lordship, Lordship is to contempt notice to the university, Lordship. And the conductor, Lordship has seen the conduct of the petitioner, how he got the appointment of registrar in the tribal university, Lordship. Then there was a regular proceeding against him. Then Lordship, paragraph 2. Then the appellant Tezpur University by order dated 21/7/2023 and passed an order relating to the grant of pensionary benefit to the deponent upon resignation retired from Tezpur. Lordship, this is again the wrong statement, Lord. He committed his technical resignation to join as a registrar in Neris, Lord. Let him deny all these things, Lordship. The registrar.
Those things have already been considered, resignation and technical resignation, Milord. And after order of the single bench, Milord, how these things come in? I don't have any objection.
Lordship,
If they are put-
again, Lordship, the registrar Tezpur University have made detailed calculation of pensionary liability of the Tezpur University and case equivalent of unutilized earned leave in respect of the deponent. In the said calculation, the university authority has fixed monthly pension of rupees so and so per month. The amount of gratuity is fixed at rupees so and so, being 1/4 of the basic pay. So and so is calculated as equivalent to the utilized term of during the service period. It may be stated here that the Tezpur University authorities have already released the general provident fund amounted to so and so. The deponent is claiming following amount as fixed by the university towards his pension and other retirement benefit mentioned. Then paragraph 3. The deponent submits that the above calculation of pension and other retirement benefit are required to be paid to the deponent in view of the service of he rendered at the Tezpur University. The deponent submits that he is no further claim in the matter of disposal of his pension and other retirement benefit. Basic on this, Lordship, the division bench passed the order. And Lordship, pension rule says that an employee is entitled to pension from the institution from where he has retired. And Lordship, see the conduct of the petitioner from Neris, he was criminal case was there, he was dismissed from there. Then considering all these facts, he got service in that tribal university, Lord. From here also considering the material facts. And admittedly is not retired from the Tezpur University. How is the Tezpur University required to pay pension to him? Only we are required to calculate his pro rata pension that is to be transferred to the next employer. But as per direction of this court, directly it was paid to him. In any case, Lordship is not entitled to any pension from the Tezpur University. Even if his contact is Lordship for the time being is outside Lord. And his contact Lordship is
Mr. Sonia,
Well-
this affidavit, your
Yes.
affidavit,
Yes. What I have said,
in paragraph number 3.
no,
he has
your Lordship,
clearly
no,
stated that
I,
he has
I
not
put
ordered it.
paragraph then that the deponent submits above calculation in paragraph 2. Above calculation of pension, I have set a pension here in paragraph 2.
No, a later part of this paragraph number 3,
Yes, no, that is true.
the last paragraph, last line.
The
the
deponent
deponent
submits
submits
that he has no
ordered
further
it.
claim in the matter of disposal of his pension and other retirement benefit. What I stated, Milon, the deponent submits that the above calculation of pension and other retirement benefits are required to be paid to the deponent. I am entitled to this, that I have stated, and no further claim.
But there is a direction of the division bench to pay
What is
provisional
stated,
pension
Milon?
to you.
As this is my year, you have seen the affidavit. On the basis of this affidavit and the last portion of the order that I have given at paragraph. clear that after receiving the said pro rata pension. About pro rata pension, I have mentioned in paragraph 2. And court also stated that, division bench. It is clear that after receiving the pro rata pension amount, the petitioner he has no other right to raise any claim against the Tezpur University for benefits, including pensioning benefits. But other pensioning benefits they have paid regarding CPF, then retirement gratuity, and leave encashment. Then last line again, it is clarified that the order of the demand was passed by this court while hearing the learned counsel appearing for the parties at length and finding that no case for interference. This is important, Milo. No case for interference is made out against the impugned order. That's the demand passed by the learned demand. Then the division bench order stands, Milo. There is no verification of it. Only I stated this pension amount has been calculated and I am entitled to that. Court has accepted my affidavit that way, Milo. It cannot be truncated and put in different forms as is convenient to my learner train. What the court says, that is important. And the learned single judge's order, he now says that I am not entitled to pension. Accordingly, this petition is disposed of, directing the respondent at page 36. As page 22 also, it says, his prior service rendered under central, at page 36, central government and Department of Accounts, Dhanbad Mines and Technology could not have been ignored and was rightly taken into account by Tezpur University while calculating pro rata pension. As the North Eastern University naturally has no pension scheme, the pensionary benefits required to be paid by the university will be paid by the Tezpur. Can he assail this order now, Milord, again, by this affidavit in this case? That is my humble submission. By putting all these matters in the affidavit, Milord, can he challenge that? Milord, I am not entitled to pension from the Tezpur University. Can he say that I have resigned technical resignation, so I am not entitled to pension? They ought to have gone to the Supreme Court then. You are not in the beginning I stated there is not a review application, Milord, before this court. You are supposed to comply with this order, and whether it is to comply to it or not, your lordship will get satisfied and do the needful. Accordingly, the petition is directing the respondent as primary to release process. Can he now say that I am not entitled to pension now by this affidavit? Can you take this into account, Milord? Here, it is not, as at the beginning I stated, it is not a review of this order. In view of the finding of the court, discuss about the impugned order that the order was set aside. Calculate pensionary benefits payable to the petitioner and release him the said amount specifically. Pro rata, they said, Milord, if one is permanently transferred, then it is called pro rata. I was taken as permanent transferee, Milord, at Tezpur University, and I resigned. Since I resigned from that university, Milord, under the pension rules, Milord, I am entitled, because Rule 5 says, it is not a hearing of the matter, Milord, but still then I will apprise your lordship about this. Rule 5, Milord. Claim to pension or family pension. Any claim to pension or family pension will be regulated by the provisions of these rules in force when the central government demands. 2. the day on which the government servant retires,
That is to be
comma,
noted, Lord.
is retired. I am not retired, I resign. Then go further, is discharged or allowed to resign from service. I was allowed to resign from service. So where is the complicacy? Merely there is technical education, technical resignation is for continuation of the service. If I resign from Tezpur University, I don't get extended service in the other institute. But I said I do not want that because they have no pension benefits and I will take pension from Tezpur University. That was denied to me. That's why I came to the court.
Okay.
So
Just
there
for
cannot be
clarification,
complicacy.
Lordship, may please to see their prayer, page 12 of the writ petition. Anything has been submitted. Page 12. It is therefore prayed that the Honorable Court please to admit the application, call for the records and case and issue rule calling upon the respondent number 2, 3, 4, and 5 to so go as to why the impugn order dated 37/2024 should not be set aside and quashed after hearing the parties and perusal of the record and causes that may be shown set aside the said order. So his bench there is to set aside order dated 37/2004. In response to their petition, this affidavit is been filed, clarifying all the points, Lord, which he has been suppressed. Lordship, my learned friend has placed the rule which says that after retirement or discharge, here Lordship,
Or resign.
yes, Lordship, may please to see.
Or resign. Or resign.
He, Lordship, he filed application for seeking extraordinary leave to join the NARIS as a registrar. What happened there, Lordship? His resignation letter, page 53.
Concerned with that.
Why it is, we are very much concerned. And it is duty of the respondent to disclose every fact before this honorable court. Page 53, again, his
I may point
resignation.
out one thing, Milord. These facts, Milord, were also agitated before the division bench. So can he re-agitate these matters again here?
Lordship, may please to see page 53.
And
His
these are
own
under my
language, Lord.
resignation from that.
I was released initially for 1 year
Concerned with that.
with EOL with paper to join the post of Registrar Northeast Regional Institute of Science and Technology. Later on, further extension was given for 3 months. Further extension could not be considered as I was asked to resume back the Tezpur University. By your letter dated 29/7/2007, within 1 month, Director of NARIS has also given his consent. By his letter dated so and so. Considering the above, I have decided to continue as Registrar NARIS and to submit my technical resignation from the substantive post of Deputy Registrar at Tezpur University. As such, the requirement that my technical resignation with effect from 14/5/2007. What remains, Lordship? He is not retired from the Tezpur University. And unless he is retired from Tezpur University, he is not entitled to pension. Our duty is to transfer the pro rata pension to his next employer, Lord. But as per direction of this one, that was paid to him directly. Let him deny that he has not received. Then he was, Lordship, page 54, the conduct of the petitioner. The service of Sri Ashok Singh was terminated during the probation period due to involvement in criminal activities in the campus. His laws is all right to claim pension. He is not claiming pension from either from this university or another university, Lordship. Then, Lordship, next page 55, it is very clear that how he got appointment in the Indira Gandhi National Tribal University. His service was terminated. The employee who is terminated from service is not entitled to pension, Lordship. This is the rule of. And he from Tezpur University is not entitled to any pension because he is not retired from Tezpur University. In paragraph 6, we have stated clearly, Lordship, in our opinion.
Part 30, that by Mr. M. Roy, Learned Counsel. SDK of the respondent number 20.
Much.
Mr. Soleha, I will keep the book with
My lord, my lord. I'll take it later. I'll take it later.
It will be attended for the time being. Mr. Ken Choudhury is on legs in another court.
My lord, my senior was here. My senior, Mr. M.K. Chaudhary, was here. He takes your lordship's liberty, my lord, to provide his reply tomorrow or day after, my lord. Subject to your lordship's convenience. He just had to leave the court premises on account of some personal difficulties. He was here, my lord. Okay. We'll just be allowed to give a reply on any subsequent day as per your lordship's convenience. Yes.
Yes, sir.
Yes, ma'am.
My lord, yesterday your lordship queried regarding that age bar, age restriction, my lord. My lord, I have asked the register, my lord. My lord, that age bar that can be, my lord, relaxed, my lord.
That can
Upper age, my lord. And in fact, my lord, for associate professor, there is no such restriction regarding age in UGC regulation as well as in Guwahati High Court, Guwahati University Act and regulation. So, my lord, that age aspect, that age bar, age restriction, my lord, that can be, my lord, considered by this honorable.
clear this.
Yes.
The act you have submitted yesterday has taken effect.
Yes. FRBM.
We are disposing of the
Section 7(1)(c).
then 1Z.
G. One post, one selected candidate.
Your lordship, LCR not received in this matter. LCR is not received.
Healthcare not. None appears for the of
Sir.
method. That has not been. Can copy of the tribe protection market. One and person
May I please hear this? In this case, lordship petitioner behind the bar motion 3 years, 3 years, 2 months.
like subject.
He is there.
After some time, what must happen?
He is there. He is the king.
14th, I think.
Please, your lordship, my lord. My lord, in this case, my lord, the only reason for not provincialization of our services is that, my lord, in the year 2016 and 17, my lord, according to the, my lord, director, my lord, there was no enrollment in the school, my lord. I had already placed, my lord, before this honorable court, my lord, on 2-3 occasions, my lord, recent time. Now, my lord will kindly have a look at page 97 and Annexure 24 that has been put to challenge, my lord. And in the last page, page 99 of the petition, my lord, it has been held that in the year 2016 and 17, no enrollment on diaspora, my lord. No, fourth line, my lord. And the respondents were, my lord, allowed to file their, my lord, counter affidavit, my lord. I am submitting before your lordship, my lord, from the records that I have placed before this honorable court, my lord, their affidavit may not be required at this stage, my lord, because, my lord, without filing, my lord, the affidavit in opposition, my lord, somehow, my lord, they filed additional affidavit, my lord, earlier, which we have received, and whereby, my lord, regarding the inspection of the our school, my lord, as I already admitted before your lordship, my lord, on 2 occasions, that on the day of, my lord, the inspection, my lord, we had to leave the school, my lord, because one of our close relative had died, my lord. Therefore, we could not be present in the school, my lord. And regarding this inspection, my lord, no prior notice was issued to us, my lord. If your lordship remember, my
Lordship
lord,
will give some time, my lord. We'll be filing our affidavit most probably, my lord.
my lord, on last occasion, my lord, 3 weeks time was given.
I was actually, my lord, I didn't appear in this.
5/8/2025, my lord. And from the record itself, if your lordship kindly turn to, my lord, page, my lord, 984, my lord, annexure 18, my lord. This will clarify, my lord. The stand taken by the, my lord, director is not correct, my lord. Lordship, for a moment, lordship will kindly have a look at page 84, miss. This is the inspection report which was conducted on 5/5/2017, my lord. It shows that the total number of students in my school was, if we count, my lord, it is 160, my lord. And in the interview order said that the concerned director said that there is no enrollment on their schools for the year 2016 and 17. So therefore, my lord, this order is not sustainable in the eye of law, my lord, as per the inspection report dated, my lord, 5/5/2017, page 84, passed by the SI of school, my lord. This was never disputed by them.
Let them file their affidavit.
Yes, my lord. We'll be bringing on record, my lord. Because my lord will give us 10 days, my lord.
No, it's the next week, my lord.
Already,
Yes,
my lord. For some reason, my lord, I was not, my lord, in this matter previously, my lord. So, my lord will kindly grant me 10 days, my lord. I'll ensure that the affidavit is filed. Otherwise, my lord, an additional affidavit was filed by the secretary. Let me get my lord full my lord instruction, my lord, from the directorate as well. And my lord, therefore, after that, my lord can proceed, my lord.
My lord will kindly fix a date just on the 10th, my lord.
Yes, ma'am.
If so, part by yeah.
Take it.
Very- very- right.
Take my document.
Right.
But can it be on
10th of September?
9th of September? Yes, sir. Deeply.
My dear, no further.
My lord.
By this,
My lord. Deeply obliged.
after 5 minutes,
My lord.
Here I have received instruction, and as per my instruction, the petitioner is approved for retention and normalization of the post of Hindi teacher of Podum Kumari Balika High School, Kamrup. Finance department has approved on that thing. That is under process and on it.
did the inspector.
My lord, only my humble prayer to Lordship and to my learned friend, my request
that this petitioner is in great hardship. She is suffering from gallbladder operation, has been done at nursing home, Kolkata nursing home, and however, she is attending the
No,
school.
no, that's all right, but they
Madam-
are in the process of
Yes.
the order.
Yes, ma'am. I am grateful to the Honorable Court and to the Government Advocate. And only
No,
the
no need to
Yes.
be grateful to the court and also to the council. We are doing our duty.
my lord, and only because of the
So wait for 1 week. In the meantime, they will
my lord, kindly they may direct to the release the salary areas as early as possible. As early as possible.
RC. So yeah, by of the person order dated 27/25. For 10 that by court has obeyed concern regarding the process of act of approval of detailed sir being held by the while served follow in Patna High Five. Then subsequently and then the department of the open of five had taken the matter and the process is in the process to communicate the direct state or order of the backdrop of the hope and 1 week time
10 days, my lord.
Right.
10 days.
right here is the of this is the matter of the letter for this for part by that part of the record.
Right. Obliged lordship.
Mobile Lordship, I think 23 Lordship, and we have filed an affidavit today, Lordship. Let it come next week with along with the affidavit, Lordship. On any
Here,
Wednesday.
my lord, affidavit court directed, honorable court directed to file affidavit explaining why 1.5 year has been delayed in provincialization. Look, my friend has filed, I have gone through the online paragraph, 2 lines affidavit, my lord, saying that my case was placed, when placed, how placed, nothing is there. So it is not compliant of this order. Kindly peruse the order, my last.
Moreover, Lordship, I have another pair, Mr. P.K. Bora. He is, Lordship, he is handling and appearing in this case. Today he is suffering from fever, Lordship. Let it come on next Monday or Wednesday along with the affidavit, Lordship.
My lord, on third, if fails, my lord, he will appear person. That order is there. Last order, my lord. Last chance also given. My lord, kindly pay order dated 25/7. Last chance given. Then 6/8/25. 6/8/25. It was stated.
And
if
record
he
also
fails,
not with
he
me,
will
Lordship.
appear personally. My lord, let it be fixed on third or fifth. Otherwise, he fails to comply, he will appear personally. That may be met. Earlier order it was there.
Let the affidavit come along, Lordship, on Monday or Wednesday, Lordship, can fix.
But otherwise, it will not. He will not comply. my lord.
For the sole contemner. Yes, yes. An affidavit has been filed.
Filed with the content of that site. Therefore, who has been dealing with this matter 3rd of September along with the
Obliged, your lordship.
there is the
Obliged.
Yesterday, this matter, the government advocate is not present. In this matter, I have already submitted the appeal dismissal order, Lordship. The government filed an appeal that was dismissed, but after dismissal of 4 months, 5 months, they have still did no any upgradation, no compliance.
Matter was placed before the personal department. That is why my lord wants to obtain instruction from the government advocate. Yesterday there was as the last time there was no government advocate. So yesterday there was no one present, my lord. It was the last item, my lord. So that is why it is fixed for today. So my learned friend is here, my lord.
though you are not a party, this proceeding can assist us by obtaining direction from your department.
Yes.
I'll provide a copy of the communication to my learned. And a copy of the contemplation may be furnished to her, my lord. A copy of the contemplation may be furnished to her, my lord, by the petitioner, and I will furnish a copy of the communication.
Lordship, only
Yesterday, what was your submission? The matter was sent to the
Personal department. Yes, my lord.
For?
For their concurrence, my lord. For their concurrence, my lord. Communication is there, my lord. It was sent to the personal department for approval in the SLC for compassionate appointment. What am I? Yes, sir.
Kindly see the direction part, Lord. Page number 18, last paragraph, Lord. The direction was to the commissioner and secretary, place the matter before the chief secretary, Lordship. I was appointed in 2013, Lordship, by the government, director of secondary education. Because of their fault, some procedural left. Till date, I have not received a single salary for 1 month, nothing, Lordship. I am serving from 2013, a grade 4 employee, Chokidar, Lord. Though the government properly apply with the SIO department approval, government approval.
Yeah. Letter. 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 That part that's the matter. This is the content SLC created by the SLC then by part has to whether they are the appellate or the court.
No, my lord.
Eh?
Because, my lord, compassionate appointment was normally the notification or OM issued by the personnel department. On the basis of that notification, OM compassionate appointment was provided to the person, my lord.
The direct by the court of by the
Because, my lord, we cannot, department, administrative department cannot appoint, my lord. Because it has to come from the SLC, my lord. That is why. And SLC was headed by the chief secretary.
The department has to place the matter directly. What you can do, you can inform the personal department that applies for the order of your sending the matter to the SLC and this for your information. But the personal department, why the matter is complicated?
Because we are ready to comply with the matter. In fact, in the last line of the communication, it has been mentioned that once it is approved by the SLC, we will pay the necessary salary, release the necessary salary.
Direction. The matter is pending in the personal department in 3-5.
Yes, ma'am.
Lordship, direction was for post factor approval.
Thereafter, after sending the matter to the personal department, your department has marked up.
That information, my lord, today I don't have, my lord. I will obtain instruction, my lord. My lord may fix it after a week, my lord. In the meantime, my learned friend,
I am taking after a week. That's it.
I will also obtain instruction whether is there any communication after 1/5/2025, my lord. 3/5/2025. Yes, special for
Report a claim, you are started. With for the with the update. Correct on respect by the secretary, the part and apply for
ये होने की ये हो communication दिया.
for the part of the copy of the along the track they did by for the goods of the day.
नाम परिवर्तन. Lordship, government advocate name may be shown in positive, then it will be easy. The name of the
Of the
government.
party
No.
out of the way. We have requested her to obtain the instruction.
Yes, obviously.
Don't try to avoid the court order.
This 24 and 25, my lord. One more case is there, my lord. The same case, my lord. That is MSc appeal number 319/2018, my lord. The Rekha Gogoi is there, my lord, 30/25. And Rekha Gogoi's another case is there, my lord. That case also be clubbed with these two cases, my lord. The next week, Lordship may fix the matter.
Next week, I'll be out of station, Lordship. Can it be on 9th, Lordship? September. Because we are ready with the argument for the hearing. Only thing, if we do not take, Lordship, don't take up this matter, Lordship, then again we have to do the same hearing in that case also. But
Same incident, same
analogous case.
analogous case.
heard Mr. Secretary.
किमान number 319 okay. ए रेखा को कोई पुरवाए
But then the number
319/2018, Lord.
no respondent
you are
item number national 25 got heavy national insurance company I'm only respondent
the photo response.
yes
The secretary
And-
learned concept of
नहीं देखा
other
हुआ
and
है।
of the matter.
Lord, I've
MSc
learned
number
anything.
319/2018.
319 2018 also pen sport and this method it will take along with and method for hearing after all 9/9/2025
Lord. Public.
Your blend.
अपने प्लेन हो जाए
Let's select.
My lord, only my lord point, my lord, was to be my lord verified. My lord, whether further proceeding was to be my lord procedure was to be adopted by the tribunal, my lord, except 165 of Evidence Act. My lord, in 15 section, page 15, my lord, the learned tribunal, my lord, found that the husband of the my lord deceased employee was a government employee, my lord, in exercise of my lord the power under section 165 here Evidence Act. Okay. Accordingly, my lord, award was my lord. That award has been my lord challenged, lord, in this case, my lord. Already, my lord, hard on merit on only to that point, my lord, was my lord kept adjourned, lord.
Is number 15
15 lords of the my lord MSc number 332. We were the claimants, lordship.
is number 15
15 lordship, 15.
yes what is the point
My lord, the Honorable Supreme Court, my lord, judgment was referred lordship. Herein, my lord, married lordship. The Honorable Apex Court in the case of Arun Agarwal versus HDFC Agro General Insurance Company reported in air so and so has held that in the case of a spouse, 1/3 of the earning spouse should be taken as his her contribution earning for the purpose of competition of compensation. Claimant number 1 during preliminary examination stated that being a government servant, sub-engineer in PWD drilling division, Barpeta received monthly salary of rupees 51,000 at the relevant time as stated by him during his preliminary examination. Claimant number 1 also stated that he also paid income tax of rupees 13,000 approximately for the year AY 2018-2019. As such, he has net monthly earning of rupees 49,916. Although no proof in that regard has been produced, the sum appears to be reliable. Considering the sum to be the basis, deceased earning in the present case would be rupees 16,638 89 paise, being 1/3 of 49,916 as per the issue of the aforesaid judgment given by the Honorable Apex Court. My lord, this is the point, lordship. And this, my lord, is challenged by the, my lord, appellant. My lord,
Yes, Mr. Goswami. So your grievance is this 1/3
Yes, sir.
of the salary of the husband.
On the last day, Lordship, this honorable court had also suggested that whether he can bring any evidence, proof of the income of the, because husband is still alive and working. That was the point. It should not be so.
The salary certificate has not been.
Not been produced. There's no proof. It's a statement of the judgment. Lord. It's a statement in the judgment that although no proof in that regard, this appears to be a little arbitrary, so without any proof. The husband, the claimant could have been asked to produce the proof. A sitting or serving government official can definitely adduce evidence of his proof of it. He was the claimant. He could have given that his claim. This is my income. 1/3 of it should be taken as that. That ought to have been the line of evidence for that. If they wanted to take benefit of this argument, judgment, that was the only proper thing to do. Produce a copy of the.
Then I will produce, my lord.
That was the last time.
Yeah, my lord, if you lordship permit, I will produce, lordship. The income tax, my lord, return, IT return as well as the salary certificate.
That will be better, lordship. That will be. I have nothing to complain about.
I am ready, lord.
File an
Please,
external
yeah.
affidavit.
Yes. I'll file it.
On record also.
Lordship, yes.
I have nothing
That
to.
may be fixed.
Or,
More power.
in item number, in both the items you were the appellant.
No, he is the appellant in the other case.
Uh, or 33221.
332.
You are.
I'm the appellant in 332.
I am for 28. And also our income. For 85. And the epic summit both the epic. The comments submit that to movie taken. We had done this sometime. Bring on record the salary certificate of the husband of the deceased and also the income tax return.
Pertaining to that period.
Additional affidavit. By filing an affidavit, there is accordingly allowed. After doing,
My lord, that may be fixed, lord. That may be fixed, lord. She is up. How like? How like? How like?
This matter earlier, the Kaushik was appeared and matter might not remain part hard. And moreover, I have charged the record, but my lord,
Record is voluminous, but matter is very small parameter.
but my lord, the inquiry report here submitted is not mentioned the date, and moreover, as per the order, it was stated that in this regard, Office of the Deputy Commissioner Nagaon have furnished inquiry report by letter dated 18/5/2020 and dated 12/11/2021. The earlier report of the Deputy Commissioner Nagaon dated 11/5/2017 and a recent report as mentioned above are contradictory. So my lord, regarding and thereafter hearing was conducted. So my lord, a report of 18/5/2020 and 12/11/2021 and hearing a record has not been found here, my lord. So sometime may be granted so that all these materials can be detected from this report. Or otherwise, I have to send the letter.
we are concerned the inquiry report.
Yes, my lord, and hearing. Because here in this order that my lord,
Why the proceeding is necessary?
my lord, there is a contradiction, and as per this report, it is stated that they were unauthorized absent. So, they do not fall under the criteria laid down the then fixed pay teachers who were now getting the benefit of ROP pay as per the government approval. They are unauthorizedly absent earlier. So they were not allowed.
What is the video?
No, there is nothing, not that.
16 probably.
I'm just very shortly, I'm there. The petitioner was appointed, all petitioners were appointed as a assistant teacher. After due selection process, they prepared. Not only them, that 200, more than 270 teachers were appointed at that time. After some period of time, they are joining their post. The government found that some of the teachers, always, they are not against against this sanction post. Selection was made. They are wrong. The government think that as they are under a due process, advertise and election, they allowed to continue. And in the meantime, they are giving in the 2,500 in stipend fixed pay. Most of the person is came before this code, and thereafter the amount is enhanced to 15,500. In due that process, some person was left out from getting that 15,500, and 4759 honor is marking that they were not getting. Thereafter, they have made a cabinet memorandum to giving relief to them. I have annexed that what cabinet memorandum in my case. They are specially stated. And after their report and all these things, they sort out the name of 52 and Nagaon district 45, whom we are concerned. After that, they again issue the enhancement of 15,500 to the people, person concerned on basis of that cabinet memorandum, and they have in their affidavit in my case, and also given to that cabinet. This is the cabinet memorandum, and it is approved. My name is listed within the 45 days, and their name also is included in 45%. What happened when they making the list again? They left out 7%. Again, left out 7%. I am one of the 7. I filed an representation before the authority and claiming the enhancement. My service is, I am continuing my service, enhancement. And in the meantime, they have also inquired the matter. They wrote to the deputy commissioner, make an inquiry. A ministerial inquiry has been taken place, and thereafter a report has been given to the authority stating about my status and all these things. Report of the inspector, report of the executive magistrate, in all documents state that so far my petition is concerned, I am continuously in serving only 7 except only 4 months in a period which I am from my gynecological problem, I take the leave, and that is also indicated in the report. What happened after the hearing? They make a hearing. What they have did, very interesting. Also, I submit. There are many reports in the meantime. There's many before the office memorandum, after the office memorandum. They picked up a report of 2017, where said that I am absent. I am irregular. And interestingly, Lordship, that report was subsequently modified. I have annexed that order. The impugn order has passed, stating that, not considering all these things, stating that, when I will place one by one, that 17 which were already been modified, not in the field now, is better than subsequent inquiry. Ministerial inquiry is not good, not in terms say not good, but that is most exhaustive. See, I annexed all this document. And now my question is that report saying that I am working, Ministerial inquiry say I am working, headmaster said I am working, inspector of school said I am working, and they rely a document which is already been not in field. If a administrative order is subsequently modified, then thereafter they can act upon the earlier order. That is the case. And there's more illegally, they said that I am not working. But where is that? That I annexed all these documents. And if Lordship said a ministerial inquiry, the record is there. Inquiry has done very exhaustive manner. They take the evidence of school inspector, they took the statement of headmaster, they took the statement of students, all are statement of the ministerial inquiry, not a general. And after that, Deputy Commissioner find a specific report before this. They said, when they came to know that they are fault now, they passed this impugn order and stating this thing, nullifying all this order, and said, that is how it can. And that is also very serious in matter, because when the cabinet memorandum is filed, in cabinet memorandum, I can show you from the cabinet memorandum already I annexed, and they have also said that this is the cabinet memorandum. That document is already in the record, and in that also said, and that period of time, I am working, I am regularly working, everything is, the report is there. How now they can say that I am a particular 1 or 2 months, I am not. If suppose, presuming I am not present 1 or 2 months for medical doubt, there is another option. You cannot say me the illegal or irregular. Did they file any, did they make any action on that? They have a right to action. They have not. The school managing committee or obviously they are allowed to give me for 3 months for they are in non-critical issue. They on 3 months, whole period of starting for the 10 to 15 years, they 3 months. Even that 3 months, even that can adjust in the normal leave. This is the case before your Lordship. For one petitioner is concerned.
My lord, let the B Kaushik come and he is to the out of station, my lord. So next week, Tuesday or Thursday.
My lord, may I submit? My lordship was pleased to. My lord, my 4 petitioners are there, my lord. One has already died, my lord, during the pendency of this petition, my lord. And now another petitioner is now on the verge of retirement, my lord. That's why the urgency. My lord, the case is very simple, my lord. A cabinet decision has been taken by the state cabinet to regularize us wherein 45 numbers of teachers' name had been included. My lord, before that cabinet decision, my lord, a thorough inquiry was made that whether we can be treated at par with the other category of employee of similarly situated or not. Accordingly, my lord, when the cabinet took a decision that yes, we also fall within the same category, So therefore, my lord, there was a decision and direction that we should be regularized with a fixed pay. Now, my lord, while the pay was given, the 7 numbers of this petitioner has been excluded from that purview, my lord, without assigning any reason. Now, my lord, when we approach before the authority that why our services has not,
They were among those 7.
yes, my lord,
Those 7 candidates who have been left out.
who have been left out, my lord. Now, in this petition, my lord, 4 numbers and my respected senior friend is representing only 1 petitioner, my lord.
Okay.
Now, my lord, my respectful submission before my lordship is that when the state cabinet has taken a decision, my lord, there is no scope for the administration or the executive to reopen. They cannot reopen for further inquiry, my lord. Now, what they are doing, they wanted to override the decision of the cabinet and go for a fresh inquiry, fresh examination that whether we were working at that relevant period of time or not. My lord, with all respect, my lord, what I respectfully beg to submit, my lord, the cabinet, my lord, after considering all these aspects, that whether these persons are similarly situated, whether we were working regularly or not, when they found us fit to be regularized, my lord, then only this decision was taken. Now the commissioner and secretary, my lord, by overriding the cabinet decision, is now taken up a suo motu decision that, my lord, our services cannot be regularized, and therefore, my lord, the impugn order had been passed, which my lordships may be pleased to find. I have annexed the impugn order, my lord, is at page 62, my lord. My lord, I am skipping the, my lord, first few paragraph. Findings, my lord, can be pleased to find. During the year 2001, for filling up the vacancies in schools all over the state, the government in the secondary education department issued instruction to the inspector of schools by WT message number dated so and so for carrying out the appointment of the graduate teachers in the vacant post. But subsequently,
yeah.
my lord.
Okay.
Yes, my lord. That cabinet memorandum, my lordship may be pleased to find is at page, my lord, 35, annexure 2 of my petition, my lord. Yes, my lord. This is a very vital decision of the cabinet, my lord. Payment of fixed pay of rupees 15,500 per month to 52 graduate teachers of the different higher secondary and high schools of Nagaon and Sonitpur district. My lord, may I read, my lord? During the year 2001, for filling up the vacancies in schools all over the state, the government in the secondary education department issued instruction to the inspector of schools by WT message so and so dated so and so for carrying out appointments of the graduate teachers in the vacant posts. But subsequently, it came to the notice of the government that the concerned inspector of schools in some districts appointed teachers in excess over the vacancies as allowed to be filled up. While the aforesaid government instruction for the various reasons, the teachers recruited in excess were not terminated from their services and they continue to work. In compliance of the order passed in WPC number so and so, the government issued another instruction to pay these teachers who were recruited without keeping parity with the approved vacancies a lump sum fixed pay of rupees 2,500 per month, and also allowed them to continue in service till termination from service or regularization of service. The fixed pay of rupees 2,500 has been enhanced to 15,500 by notification so and so. The following is the position of the such teachers appointed in the different districts who are now getting pay of rupees 15,500 per month. Milord, here is the Milord distinction. The district wise category has been made. Milord, Sibsagar, Nagaon, Sonitpur, and Lakhimpur. Now, Milord, our is concerned with the Nagaon district, Milord. Now, clause 4, Milord. But some teachers who were also appointed in excess over the vacancies at that point of time were left from getting the fixed pay, and these 45 teachers, my lord, may kindly note, and these 45 teachers in Nagaon district and 7 teachers in Sonitpur district. My lord, we fall within these 45 numbers, my lord, are still working but not getting any fixed pay since their appointment. Considering the entire matter, the department took the step and called for a working status report from the deputy commissioner and the inspector of schools Nagaon and Sonitpur district. Accordingly, the Deputy Commissioner and the Inspector of Schools had submitted a detailed report stating that these teachers in Nagaon and Sonitpur districts are working without receiving any fixed pay. Since joining the Inspector of Schools, Nagaon had also identified equal number of vacant posts for adjustment. My lord, from this paragraph, my lord, it very clearly discernible, my lord, that the Inspector of School and the Deputy Commissioner has opined that we were working at that relevant period of time, my lord. So therefore, my lord, the 45 teachers has been taken care of from the rest of the paragraph, my lord. If my lord may be pleased to peruse, my lord. Now, my lord, may kindly turn the list, my lord, wherein I have annexed in page number 39, my lord, is a list of 45 plus 7, my lord. 45 of Nagaon district, my lord, wherein the name of the petitioner, my lord, may be pleased to find in page 41, my lord.
That's all right. Now,
My lord.
so that decision is being taken by the cabinet.
My lord.
Inquiry was done
Enquiry was done, my
by
lord,
the Deputy Commissioner and also
by the Inspector of Schools, my lord. Exactly, my lord.
So as per that inquiry report,
We were working, there is no unauthorized absence, my lord.
unauthorized.
My lord.
If this is the cabinet decision, then the Deputy Commissioner can also.
Exactly, my lord. The Deputy Commissioner, when the before the cabinet took a decision, my lord, the
There is a decision of the Supreme Court.
my lord, my lord,
If the cabinet has taken a decision,
my lord,
the government cannot take another decision.
my lord. No, my lord, cabinet, my lord, with all my, my lord, with all respect, with my limited knowledge, my lord, what I respectfully beg to submit, my lord, cabinet is a constitutional body, my lord.
That's all right.
My lord.
The government, that is the executive cannot take a different decision.
Overturn the cabinet decision.
Yes, yes.
Now here is an
Can
attempt.
you find out that
Yes, my lord, I can
earlier,
place it.
earlier I have referred that decision on the
Yes, my lord, I also, my lord, I have found in a matter, my lord, connected with this nature, my lord. I have also forgotten that, my lord. But I can place the judgment, my lord, before my lordship. Now, my lord, what they are saying, my lord, very unfortunate that rest of the persons, my lord, has already been has already got the benefit of fixed pay. Even their services has been subsequently regularized also with the ROP rules, my lord. They are now getting salary with the ROP. Now, on the other hand, my lord, we are running from pillar to post in the office of the respondents, my lord.
you produce that judgment.
Yes, my lord.
Take a final call on next.
Yes, my lord. On next date, we'll place it, my lord.
Bordua.
Well.
Number.
My lord, I am in 935 and my respected senior friend is in the next item, my lord.
Next item.
Well.
Yeah. So the paper, the for 935.
Mal.
Usurper furnace.
Secondary education.
Secondary part. Upset. Six.
Report from this background, I know. Report.
Inquiry written.
Itu pada dia tu bisa itu.
Certain methods and where is the port of
Mal.
On that day, they kindly directed them. Always they came with a part of the document. They directed him to inquiry report, which is sent by the deputy commissioner on basis of the order pass. That must be in place. Where there is a ministerial inquiry, everything will be clear from there. Though they are not entitled to do this.
After the cabinet.
Yes.
Whether they are like further.
No. In fact, when we claim our right on basis of the cabinet memorandum, they want to hear the matter. They take the evaluation and pass the order. And in the meantime, they also, what did I am not disputed. They write to the deputy commissioner to know the status, status, our status on 2020. And the deputy commissioner, on basis of that, they make an inquiry and send it. After that, their duty was have to be, they release the payment to us. But without doing so, this thing is happening.
What is all that?
May it pleases my lord. My lord, Mr. B. Chaudhary appears for this matter, my lord. As on today, he is on bereavement, my lord.
Pardon?
He is on bereavement, my lord. Conducting counsel, Mr. B. Chaudhary.
He is?
On bereavement, my lord.
Somebody died.
When can
Long
it-
pending case, my lord.
long pending 2018 matter.
They
Relates to what?
2018.
Relates to?
It relates to, my lord, equal pay for equal work.
Okay. You are working as?
They are working as district project engineers in Sarva Shiksha Mission Abhiyan. They are diploma holders and others are degree holders. But in the very advertisement whereby they were engaged in the work, they were inducted in the service, there was a difference. Extra 15 years experience criteria was added for the writ petitioners. On that point, they were equalized with the BE degree holder. And thereafter, their scale remains same for a very long time. And all of a sudden, their scale has been changed, and without reason, that too.
Yeah, that will come.
And
We'll take the sort that.
My lord.
yes,
The next.
yes,
The next day, he will apply the court, my lord.
Your good name, please.
yes, R. Sharma.
And sir,
H. Burwa, my lord.
H. Borwa, Colonel of the Deputy. Sir,
B. Chaudhary. Pending counsel. SSA, my lord. I don't have the BD.
the Borwa company that is on period and rest of next Court of chapter.
Huh?
Court of
Court of. Earlier placement.
Yes,
This is a case of termination, my lord, no SSA. So here, some record, some information is required for adjudication because the allegation against the petitioner that he is a district project engineer, he has misappropriated some SSA fund, but but this RTI reply and their affidavit says that he cannot directly handle the SSA fund. It comes to the SMC, School Managing Committee, and his duty is to supervise and give the completion order, work completion order, then only fund will come. Now allegation is that he has submitted false work completion order, but in all their affidavit, that documents is absent. In 2 years back also, this honorable court has asked them to
document relating to
that is work completion order.
work.
Yes, that is the vital documents. Otherwise, he is not directly involved.
That document was issued by you.
Yes, that is their allegation.
Allegation.
I said that I have never issued that
Document.
Yes, and when I have applied for the bail application, this honorable court in 2012, the case that is called for, this honorable court is satisfaction that there is no completion order on that counts. The AB was granted. Yes. Now that documents after 10 years, 12 years not produced, and there is a direction also. So today also we have gone through it, but that documents is not there. This main head, that is this misappropriation, that will not be directly established. And if the misappropriation be done, then their headmaster or others, they should be also be implicated, or then it will be proved. Only the allegation that he's using his power is misappropriated by giving the work completion order. So that is
For a moment, my lord, may I take my lord with me to page number Two,
Are you ready to argue?
no, my lord, Mr. B. Gogoi is appearing in this matter, my
So that is why, my lord, that may be fixed after 10 of September, and in the meantime, and that documents may endeavor may be taken.
My lord, we have filed our.
Is there any direction earlier?
Direction, my lord, it is just my lord Justice M. Bujur Burwa, that was the instruction is 2 years back. Now I cannot figure out this order. But in their affidavit, the documents is absent, this is voluminous affidavit. So that is why I have pointed out, maybe fix it September 2nd.
Order dated 10/10/2023. There was a direct order work.
Yes, that is best. That is why I point.
My lord, whatever needed, we have stated in our affidavit, my lord.
Oh, I see.
Whatever our department has to say, my lord, we have stated in our affidavit.
Do you produce this
Pardon, my lord.
Do you produce the work completion certificate as per order of this court? That order?
Yes, this in my voluminous affidavit, I have not found.
Work completion certificate.
Yes. Photos, yes. They're going here and there, but that metal documents is absent. So, honor, this honor,
Mr. Borua.
MJ Borua.
For the and Mr. Borua for Borua, if it
B. Gogoi, my lord.
Now it is B. Gogoi.
B. Gogoi, my lord.
Oh, B Gogoi. Oh, the SSA.
SSM, my lord.
The Borua has pointed out that by order dated 10/10/2023, director the origin and complete certificate or complete certificate relied upon by the authority in the beginning, and the state document has not yet been produced and ordered that duplicate being laid production of the state document very direct or the origin or taking the next step or this was 18
Bless.
Yes, my lord.
So I'm respondent number 4, Lordship.
Where is the at 2 p.m. then?
My lord, matter may be taken up on 4th, my lord. On 4th, next Thursday, my lord. Both the seniors will be available on that day, my lord.
4th of May.
My lord,
Sorry, 4th of September.
on Thursday.
Thursday.
Thursday. 4th.
Okay. As I did by Lord and the part.
Most of them.
In this case, on last occasion, Lordship directed me to produce a certificate copy of the evidence recorded. Lordship, we applied, but we could not get the copy. Maybe taken on Wednesday, Tuesday or Wednesday.
Sir,
Every day.
So APT hoc, product fire, the fire that by the order date 5. He was directed to produce the certificate of the evidence of the editor examined by the current trial court. Then he had applied for the same. Then he has not received the same till date.
Lords.
Then a best of
Witness till witness
Dear Lord.
Macho.
Wait, Lordship. Lordship, may kindly peruse the order date 29/11/2023. Paragraph 11, my lord. In view of the above, the state authorities are required to produce the complete records, more particularly in relation to the communication dated 28/6/1993. 28/6/1993 is the, my lord, office memorandum on the strength of which the petitioner was upgraded to the post of assistant teacher from the post of law division assistant. So, my lord, this honorable court was of the view that this is the document is required under what circumstances this decision was taken by the government. My lord, that record, whether it is available or not. If it is available, my lord, I will start my proceeding. (28/6/1993). No, that record is not available. In fact, no such record is available in the office. I have received the record, my lord, regarding, my lord, last hearing conducted in the year 2023.
Regarding the communication dated 28.
No such record is available. They are the custodian of the record. They are the custodian of the records, my lord. In any case, my lord, his application was illegal, my lord. He holds the rule, and this honorable court has already held in a case of, my lord, Patananda Boister. There is no scope for upgradation of NBA to the post of institution. That issue has already been decided by the government. I am relying on that decision. They have not filed any affidavit. State has not filed any affidavit. State has not filed any affidavit. State has not filed any affidavit. Yes, then it should be. It was already decided by the government. It is not required.
So that was serving as LDA.
LDA.
Then he was upgraded as assistant teacher. Then the present case.
Same, my lord. But, my lord, in that case, my lord, that upgradation order was put to challenge. In my case, my lord, no one has challenged my upgradation order. It is not required, my lord. No one has challenged my upgradation order. It is not required. And, my lord, my lord, rule is, my lord, 10th under 19, my lord, 309, Article 309 of the Constitution of India.
Whether your upgradation is supported by rules.
Yes, the rule doesn't support, my lord, because, my lord, the LDA in a school is a single cadre post, my lord. There is no promotional avenue. for
that
the LDAs.
that you have to be upgraded as an assistant teacher or later on as headmaster.
My lord, it is the decision of the government, but that is the 28/6/1993. This was the decision of the government because there is no scope for promotion under the rule. So, my lord, government took a decision, conscious decision, to upgrade those teachers who are qualified.
Is that decision is part of this record?
Yes, my lord.
Page number?
Page number, my lord. 21. Page 21.
So you have been upgraded on ad hoc basis.
Ad hoc basis.
Thereafter, it was
Thereafter, my
placed
lord,
before the,
my service was confirmed.
was it placed before the district level?
Yes, ma'am.
And the board has confirmed it.
Yes, ma'am.
Lordship, it is not record, Lordship. And another,
Not asking. Where is the decision of the district court?
My lord, that decision is not me, my lord. That decision, my lord, my friend was directed to produce the petition regarding the, my lord, election of the petitioner. And my lord, the confirmation order is there. My lord, the issue in this case, my lord, the impugn order which led to, my lord, from a order
No,
passed by the Honorable Court.
So yeah, your contention that the matter was placed before the district level court, and the district court has approved your proposal.
My lord. And thereafter, my lord, my
Where is
service
that district level court jurisdiction?
will collect the select list, my lord. Whether my petitioner has the collect select list or not, my lord, I am not sure. But my lord, confirmation of the order he has. So, my lord,
Confirmation order is at page number?
my lord, that is also not annexed. So, give me some time, I will file an additional affidavit, my lord. If the select list is there, my lord.
So yeah, you say you have to research the burden.
Yes, yes, my lord. My lord, I am obliged to my lord.
The
Some
document
time may be
are not
granted,
part
my
of
lord,
the record then, but
because my lord, that has not been, my lord, disputed by the state authorities. The authorities has not,
disputed,
that,
that
my
is
lord,
the
evidence.
department, but first you have to research your burden that you have a prima facie.
I made a statement, my lord. I made a statement. That
No,
statement has not been
will not.
controverted.
But yeah, you say admittedly, your upgradation is not supported by any act or rule.
It is, my lord, on the strength of this, my lord, circular, my lord, the page 21 circular.
Page 21 is not a circular, this is a letter.
No, my lord, it is a circular to all the inspector schools. To all the inspector schools, my lord.
It appears to be a letter, not a circular.
My lord, it addressed to all the inspector of schools, all. So, my lord,
But if it is not provided in the rule, how can you say?
my lord, the rule does not say also, my lord, that the grade sheet
No,
staff.
does not say that is a deferred
Yes,
trigger, but where it is provided in the rule.
My lord, 309 is the rule. My lord, 309 rule is a rule, my lord, which can be supplemented. Not can be it cannot be supplemented. It can be supplemented by a circular or my lord office memorandum if there is nothing, no provision in the rule.
Well, how do you justify that this is a office memorandum supplementing the rule?
My lord, that is why my lord, this honorable court one.
This appears to be a letter written by
My
the.
lord, that is the reason, my lord, for which this honorable court directed the state authorities to produce the record as regards the that circular, my lord. Under what circumstances this letter was circular was issued? What was the compelling circumstances at that moment? My lord, if the record of that letter is, my lord, circular is produced, also will everything will be clear, my lord.
Sir, Adonai?
This is not a circular.
Not a circular.
It's a communication. In fact,
No,
my lord,
but
this
is it available in your department?
no, my lord. Page 21, it's a type copy of relevant person. My lord, kindly have a look at page 22. This is not also a original copy, my lord. Kindly see the signature part, my lord. Yours faithfully as the eligible. Then in the copy column mark also, my lord, as the eligible. So there was
no signature.
no signature, my lord. So I'm disputing it, my lord.
My lord, he disputes, my lord. He didn't file an affidavit, my lord, disputing this, my lord.
In
Lord,
any case, my lord, I am
already
relying
he
the-
cannot dispute this, my lord.
I'm relying the judgment rendered by this honorable court, my lord. In fact, in the decision also, they
didn't file an affidavit that this document is forged document produced by the petitioner before the law.
there is no requirement to the effect that to file an affidavit because, my lord, this honorable court has already decided this issue, my lord, that here's the rule. No one can be upgraded from LDA to assistant teacher. In fact, page 33, my learned friend has annexed a judgment, my lord. Page 33, my lord.
Yeah.
Page 33.
My lord, that was the interim order passed in the earlier on the litigation.
Page 35, my lord.
Against that, my lord, appeal was filed. Appeal has been allowed.
Page 35, my lord. Paragraph 14.
Yeah.
In the said common judgment and order dated 2/12/2014, the court observed that the recruitment to the cadre of postgraduate teacher, graduate teacher, and junior teacher, as per the said 1982 rules, was required to be made by direct recruitment only on the basis of the advertisement, test, and interview, and said rules 1982 rules did not provide any such provision for promotion or upgradation of LDA junior assistant to the post of assistant teacher. Therefore, the court came to the conclusion that any such upgradation of LDA JA to the post of assistant teacher is illegal, and regulation of service of any such assistant teachers upgraded from LDA JA does not arise, not permissible. Subsequently, my lord, paragraph, this is the judgment referred. Thereafter, my lord,
Part 12.
page 38, my lord. The observation by this court in this case, my lord. Paragraph 35. The Assam Secondary Education Provincialization of Service Rules 1982 was initially framed under section 3.3 of the Assam Secondary 38, my lord. Page 38, paragraph 25, my lord. Was initially framed under section 3.3 of the Assam Secondary Education Provincialization Act 1977, regulating the service condition of the teachers and employees of secondary schools that came into force with effect from 29/5/1982 from the date of publishing of the said rules in the Assam Gazette Extraordinary. Since said 1980 rules that came into force with effect from 29/5/1982 was framed under section 3.3 of the Assam Secondary Education Provincialization Act 1976, it has statutory force. Said 1982 rules was later amended on with effect from so and so, and such amendment was made under the proviso to Article 309 of the Constitution of India, regulating the condition of service of the teachers of the secondary school provinces under the Assam Secondary Education Provincialization Act 1977. Thereafter, said 1982 rules was again amended on so and so, and even said 1997 amended rules was framed under Article 309 of the Constitution of India, regulating the recruitment of the recruitment and conditions of service of the teachers of higher secondary schools provincialized under the Act of 1977. After the said 1980 rules that was amended from time to time, as noted above, the Assam Secondary Education Provincial Service Rule 2003
that was framed under Article 309 of the Constitution of India, regulating the recruitment and condition of service of the persons appointed to the Assam Secondary Education Provincialized Service came into force with effect from 12/8/2003, and some of the provisions of the said rules were amended with effect from so and so, so and so. After the said rules, the Assam Secondary Education Provincial School Service Rule 2008 came into force so and so. A statutory rules under 309 of the Constitution of India regulating the recruitment condition of service of the teaching and non-teaching employees appointed to the Assam Secondary Education Provincial School Service. The Assam Secondary Education Provincial Service Rule 1982, 2003 rules and the 2080 rules having statutory force from time to time for their existence, it is provided that the post of teachers of any nature in provincial secondary school has to be filled up by regular process of advertisement and selection on the basis of merit, whether it is 1982 rules amended from time to time or 2003 or 2018 rules. In such statutory rules of 1982, 2003 and 2018 noted above, there is no such provision for upgradation from the post of grade 3 and grade 4 to the post of any kind of teachers in provincial secondary school. When the board of recruitment is specified in by statutory rules, no authorities, including the government, as settled by the Honorable Apex Court, has the power to modify or amend such statutory rules by mere circular or notification of Umarani and Umadevi. It is also settled that if anyone gets any benefit of such kind of illegal circular or notification issued in violation of the statutory rules, shall not be entitled to get any benefit from such illegal circular and notification which stands to be void ab initio. So categorically held that even there was any circular or notification, that circular notification cannot supersede the statutory rules. So it is settled, my lord.
Well, this was put to challenge before the division bench, my lord. The order of the division bench fulfilled paragraph 64.
Yes.
This writ appeal is filed by the appellant being aggrieved with the order dated 22. My lord, operative person, my lord, those will find the page 65. However, the writ petition being the petition number, so the present writ petition, my lord, is required to be decided by another single judge on its own merit without being influenced by the impugned order passed by another single judge, which is under challenge in this writ appeal. So, my lord, that order, my friend, is relied, that cannot be relied before your lordship. Because
That's the order you have filed here.
no, my lord. This interim order was passed. After that, my lord, the impugned order was passed pursuant to the interim order. Interim order was challenged before the division bench, and division bench, my lord, held like this. And the impugned order passed pursuant to the the interim order, that is under my lord, challenge, and that it has been stayed.
About this, but what about this Sadananda Boisya?
Yes, my lord. Sadananda Boisya, my lord, while adjudicating the matter, my lord, that circular of 1996, 93, that was not placed. That was not considered. That is why, my lord, the interim order.
So why should we consider now then? The original circular is not before the court. There is no signature in that circular.
My lord, if there is no denial, if there is no, by following the proposition laid down in the case of Nasim Bano, Nasim will held that, my lord, this, they have admitted that, my lord. If it is not, my lord, controverted, they have not controverted. They have not said that this circular is a fake circular. I have produced it. They have not said that there is no such circular. There is no such provision. In absence of such denial.
No. Can we act upon a document where there is no signature?
My lord, this is the document, my lord, the petitioner obtained from the.
That's right.
That is why, my lord, that is why.
Signature of the issuing authority, then.
That is why I'm saying, my lord. That is why I'm saying, my lord, let the authority deny it, my lord. If it is not dear, my lord, I will not press this case, my lord. If this circular is a fake circular, my lord, I will not press this case.
No, tell me, can it be read as a circular without any signature of the issuing authority?
That is why I'm insisting. Let the authority who issued this certificate, who I have projected to be issued, they let the authority deny it, my lord. let the authority deny it. If it is not denied, my lord, then it is, my lord, in Supreme Court, my lord, all the documents are, my lord, produced in type copy, my lord. No original documents are produced. But that is, but if it is not, my lord, denied, it is.
In that case, my lord, I would like to draw your kind attention, my lord. Since in Supreme Court, all are type copy, my lord. Here also, if it is assumed that it is a type copy, then the learned advocate who filed the writ petition, he obviously gone through the original copy, my lord.
Definitely.
Yes, my lord. Let him produce that original copy, my lord.
I will try to produce the original copy. Let my friend also deny this document. Let him file an affidavit denying my appointments in a writ petition.
Attorney, or why don't you file an
Earlier, my lord, I am not aware why I didn't file the affidavit, my lord. Otherwise, the case on law, my lord, case is very clear, my lord. In fact, the division bench judgment, it is against the interim order, my lord. And regarding the merits of the case, division bench has not decided the issue, my lord. My lord, kindly have a yes. Regarding the observation made by the honorable single judge, division bench has made no comment, my lord. Because it was dismissed as infructuous, since it was an interim order, my lord. So merit of the case was not decided by the honorable division bench, my lord.
But the division bench,
you produce the original document?
Well, my friend also may file an affidavit, my lord, so that, my lord, I get an opportunity to controvert it.
File it.
Yes, my lord, possible.
Their prerogative. They may file it.
Yes, my lord. In that case, I will rely on Nasim Banu, my lord. Please say that after puja vacation, my lord. In the meantime,
He will be retired on October, Lordship.
I don't know why the private.
Law circular cannot prevail over the law, Lordship.
I don't know, my lord, why the private respondent is shouting, my lord. My my lord, my lord, her appointment itself is an ad hoc appointment, my lord. So in the provision under the rule for ad hoc appointment, my lord, she was regularized subsequently without any selection process. How can he claim that she is senior to me?
That is already decided.
My lord, her appointment itself is an illegal appointment. If my appointment is illegal, my lord, her appointment is also illegal. She was also appointed on ad hoc basis, my lord. She was regularized without any selection process. And presently, my lord, she is holding the post of principal on interest basis. On the strength of the decision, impugn decision, my lord. How she is aggrieved by the disposal of the writ petition, I don't know, my lord. How she is after my service. If I lose my service, my lord, she will also lose, my lord. Because her appointment itself is illegal, my lord. He was appointed on ad hoc basis, my lord.
D Deca, Lord.
D Deca.
D Deca.
D Deca, number
4, Lord.
1. Heard in part, place the matter after making so here that produced the original copy of the letter dated 28 1993. Annex part 3.
The step also, my lord, may be directed pursuant to the earlier direction, my lord, paragraph 11 of the earlier direction, my lord, to produce the original record of the letter dated 28/6/1993. As there is clear direction of the court.
Ready out the direct of the order dated and if necessary by filing and
Lordship, kindly fix the date. He will be retired on October, Lordship. Kindly fix the date, Lordship. He will.
how you will be prejudiced if
I
the
don't
court
know, my lord.
decided?
Lordship, my another humble prayer is that he was upgraded 1996. He take the graduate scale 1993, Lordship. That is illegal. He was another
Yes, he
illegal
challenged
is
that.
that
Yes, he challenged my appointment order, my lord. He has not challenged.
my seniority is already decided, Lordship. I have received a graduate scale from 1994, Lordship.
If he retired in the month of October, how will you be prejudiced?
Lordship, he take the illegal benefit, Lordship, from some that there,
This is
Lordship.
my petition, my lord. He has, my lord, no prayer. Let her file an, my lord, petition challenging my upgradation order. Challenging my upgradation order. She has not challenged my upgradation order. Neither the circulars are put to challenge by her, my. Obliged, my lord.